Hello, class. We're going to talk about personal property and bailments. So, in dealing with personal property and bailments, we have to be able to talk about what is the difference between personal property and real property. So, the first thing is personal property are things that are movable. So, an example would be a book, a shoe, a backpack. Those are things that are movable. And so the area that we're going to be looking at is going to mainly be dealing with personal property. It can also include things such as intangible property, such as copyrights. Now, real property. Real property is anything attached to the land. It could be land, it could be a house. So the first thing is being able to make the classification distinction between personal property and real property. In addition, it's important to understand what title of personal property means. Title of personal property means ownership of personal property. And in some instances, like a gift, we're going to be dealing with ownership of personal property or the passage of title. In some instances, like a bailment, there will not be a passage of title. So title means ownership under the circumstances here. Gifts. So there are various types of gifts. I'm sure you've probably received gifts before. Sometimes it might be at a birthday you've received gifts, or maybe you've even given a gift. When you have a gift, you actually have a donor and a donee. A donor is the person who's giving the gift. The donee is the person who the gift is being given to. It's important to understand that the donee does not have to accept the gift. One type of gift is called an inter vivos gift, and that's a gift between living persons. In order to have an inter vivos gift, you have to have donative intent, which means that the donor has to intended to make a gift, and the gift has to be delivered. Now, these don't have to come in any specific order, as you'll actually see when we talk about the material a little bit more. Donative intent, for example, if I was to give someone a book and say, I will loan you the book for the semester, there's no donative intent there because it's just a loan. That's a bailment. If I was to give someone a book and say, you can have this, then I not only have delivered the book, which is the personal property, but I also have the intent to make a gift. There are other types of gifts that your book talk about. One type is an anatomical gift, which is a gift where individuals give body parts. And so an anatomical gift could be if I gave my kidney, for example, to my sister. There's also a gift casa morte. And a gift casa morte, or mortis, is actually when an individual thinks that they're going to die, and based on that thought, they decide that they want to deliver the personal property to someone upon dying. So it's a conditional gift. If they don't die, that the gift does not take effect. If they revoke it before they die, the gift does not take effect. Or if the donee dies before the donee, the gift will not take effect. So there are also gifts casa mortis, and they're conditional gifts. If I say to someone, once you graduate from college, I'll give you a car, that's a condition precedent that has to be met for that person to get the gift. The condition precedent would be that individual graduating from college. If I say to someone that you have to, I'm going to give you a car and you can keep it unless you don't graduate from college, that's a condition subsequent. The condition comes after. So the person can keep the car as long as that person does graduate from college. So conditions can be placed on a gift. Another example or a question that comes up with conditional gifts deal with an engagement ring. And so the question is an engagement ring a conditional gift? So if someone gives a engagement ring and the marriage doesn't happen, do you have to give the engagement ring back? That's the question. And jurisdictions have different opinions on that. Some jurisdictions say, yes, you have to give it back because the engagement ring was a gift that was conditioned upon marriage. And some jurisdictions say it really depends on who's at fault as to the reason that the marriage did not happen. There is also multiple ownership of property. So multiple owners. If I was to own property by myself, that's what's called a fee simple. But it's possible that more than one party can own personal property and also real property. So you could have property that is given to, like a boat, to three individuals. And if it's given as a tenancy in common, then with three individuals, that property would be owned by each of the three individuals. They'd each have a 1/3 interest. If it was given to two individuals, they would each have a 1/2 interest. With the tenancy in common, the interest can be inherited or bequeathed. And bequeath would mean that someone gets it through a will. Inherited would be when there is no will. And it's based on state law as to who gets it. So if there's a boat that's owned by Jack and Peter, they each own the boat as tenants in common. If Peter dies, at Peter's death, Peter's heirs would have Peter's 1/2 interest. It would not go to Jack. So there's no right of survivorship with a tenancy in common. A right of survivorship means that the owner that lives the longest, or when the owner dies, the other owners get the that person who's died interest in the property, not the heirs or relatives of the person who dies. But with the tenancy in common, there's no right of survivorship. So at death, the ownership of the property goes to the heirs or relatives of the individual who dies. There's also a joint tenancy with the right of survivorship. A joint tenancy with the right of survivorship, if you have owners, when the owners die, it does not go to their heirs or relatives. It goes to the remaining owners. So let's say Jack and Peter own a boat. When Peter dies, before Peter's death, they each had a 1/2 interest. When Peter dies, Peter's interest this time does not go to Peter's relatives. It goes all to Jack, and Jack owns the property completely outright as a fee simple owner, which means he owns all of it. Now, it can be transferred. Your interest before death can be transferred, but once it's transferred, the transfer gets rid of or terminates the joint tenancy with the right of survivorship, which means that the ownership of property becomes a tenancy in common. So let me give you an example. Let's say we have three owners. Jack, Peter, and Owen own a boat. That means they each have a 1/3 interest. Let's say Peter wants to sell or transfer his interest to Maya. He can do that with a joint tenancy with the right of survivorship, but when he transfers it to Maya, that destroys the right of survivorship. And so now, once he transfers or sells his interest, now it's Jack, Peter, and Maya. Each have a 1/3 interest, but it's in a tenancy in common. So now if either one of them dies, that means that their interest no longer goes to the other owners because it becomes a tenancy in common. It goes to their heirs or relatives. Then we can have a tenancy by the entirety, and that's owned by married couples. And it cannot be sold or transferred without the permission of the other spouse. There is a right of survivorship. And so, for example, if Mary and Jack are married and they own property as by the entirety or by the marriage, neither one of them can sell without the permission of the spouse. But when Mary dies, then her interest does not go through a will or through intestate. Her interest, because it's a tenancy by the entirety, goes entirely to her spouse. Okay, and I think I named her spouse Jack, but if not, let's say her spouse's name is Jack. Mary and Jack are married. So I just wanted to make sure, because I'm kind of thinking of these examples off the top of my head. So if I change the spouse's name, forgive me for that. All right, now we're going to talk about bailments. So a bailment, unlike a gift, does not transfer the ownership or title of the property. So when you have a bailment, you do have personal property, and you do transfer the personal property, but there's an idea that that personal property is going to come back. It's going to be transferred without title or ownership. With a gift, someone is transferring the personal property, and assuming the donee accepts it, the actual ownership is transferred from the donor to the donee. So for example, if I get a gift from my mom, say she gives me a book, she no longer owns it once she's delivered the book to me and she has donative intent to give it to me as a gift. But a bailment is different. You do have personal property because real property cannot be bailed. But with a bailment, you are transferring the personal property with the idea that it will be returned back to the bailor or another individual as specified by the bailor. So with the bailment, you have a bailor and you have also a bailee. So an example of a bailment would be if I go and I take my car to the mechanic. When the mechanic is fixing the car, the mechanic has exclusive control over that car. And so I'm the bailor. I have the exclusive control. I initially have the exclusive control over the car, and then I give the car through the keys, because you can have a constructive bailment where you don't actually pick up the item, but you give control. So through me giving the keys to the mechanic, I have given up exclusive control of that personal property, the car. So the mechanic would be the bailee. The mechanic would have possession or control of that car through me giving up the keys through a constructive bailment, but the mechanic would not have ownership of the car. And the purpose of that would actually be for the mechanic to fix the car, and then they're going to give me the car back. So that would be an example of a bailment. Another one, if I take my clothes to the cleaners, obviously I'm giving up exclusive control of the clothes while they're being cleaned, and I'm the bailor. The cleaners would be the bailee, but that there's no intent that the clothes would be owned or kept, or title ownership kept by the cleaners. They should give it back to me. So that's the difference between a gift and a bailment in one distinction. For there to be a bailment, there has to be control, exclusive control, or some type of control given to the actual bailee. And so that's something to think about when you're talking about a bailment. And there are different types or classifications of bailments. So we have a bailment that classification would determine what type of care would a bailee have. So there's a sole benefit of the bailor bailment where the bailor is the only one getting the benefit. So an example of that is if I have a dog and I have to go out of town, and dogs are considered personal property. I know we think about our dogs as our family, but under law, they're considered to be personal property. So if I was to go out of town and I asked my sister to take care of my dog, that would actually be a bailment that would be classified as for the sole benefit of the bailor. I'm the bailor, my sister would be the bailee. She's helping me out. So she only has to use slight or little care, and she can only be held liable for like gross negligence if she did something extremely terrible. There's also a bailment for the sole benefit of the bailee. And what that means is the bailment is actually for the benefit of the person who's getting the personal property. So if you had, for example, if I loaned my book, let's say we have a hard copy of a book, I loaned my book to my friend. Under those circumstances, if my friend's not paying me, I'm not getting a benefit out of it. So my friend, it would be for the sole benefit of my friend. My friend would be the bailee. I'd be the bailor. The bailor is the person who delivers the personal property to the bailee again. The bailee, the friend, has to use a lot of care because it's only for the benefit of that person. The bailee will be held for liable or responsible for even the smallest bit of negligence. And then number 3, or the third type, will be a mutual benefit bailment. And with the mutual benefit bailment, under those circumstances, both parties are getting a benefit. Under those circumstances, you're talking about just using reasonable care, and you can be held liable for ordinary negligence or if you don't act like a reasonable person. So an example of a mutual benefit bailment would be the mechanic. So the mechanic would have to use reasonable care because the mechanic is getting benefit because I'm going to pay the mechanic, and I'm getting a benefit because my car is going to be fixed. So knowing those different classifications are going to be extremely helpful.